Welcome back to Good Law, Bad Law. Today we're going to be talking about the Trump administration's proposed changes to Title IX and campus procedures to investigate allegations of sexual harassment, sexual assault, and rape. These proposals are controversial, but very little understood in my view, and we're going to be talking about that today. I want to welcome Adam Zucker, a lawyer in Blue Bell, Pennsylvania, who specializes in representing, for the most part, the accused in these types of investigations on college and university campuses. Adam, thank you so much for being on the program.
Thanks, Aaron. I really appreciate being here.
We're going to talk about these proposals by Education Secretary Betsy DeVos. You know, she has been a lightning rod, in a sense, one of the more controversial figures in the Trump cabinet since she started in that position. But I think as we're going to see as we work through this, the controversy may be somewhat misguided. And we're going to unpack that and talk about some of the specific cases that you've worked on to help illustrate that. But I thought it was fascinating in an article I read just this morning that these proposals that we're going to be talking about today have come under fire from a lot of different places. President Obama, former President Obama and Joe Biden started a sexual assault advocacy group called It's On Us. And in response to these proposals, they have actress Alyssa Milano comparing Betsy DeVos, the education secretary, to the Grinch and saying that we should all, quote, return the supremely shitty gift, namely these proposals. The pro-choice group NARAL called these proposed regulations horrifying. And the ACLU, which usually is on the side of making sure that even those who we may not like for their acts, including the accused, nonetheless get every protection under the Constitution that we have available, the ACLU has called these proposals regulations that, quote, would make schools less safe for survivors of sexual assault and harassment. So the ACLU weighing in opposition. We need to understand what these proposals are looking to change, what the system was, and Adam, what you've seen in your practice in some of the cases that'll help us understand how these issues play out on college campuses across the country. So that's a long way of setting the table here. But why don't you start by giving us a bit of background on yourself, how you came to take on these kinds of cases, and really just in an overview sense to begin with, what are the kinds of cases that we're talking about here?
Sure. I have been practicing in the southeastern Pennsylvania area, primarily Montgomery County, for almost 30 years now. Right. And a vast majority of my practice initially was criminal defense. And given the large number of colleges and universities in the greater Philadelphia area, I would have a client come in with a criminal case, there would very oftentimes be a college disciplinary action attached to that criminal case, whether it be for a sexual assault or a drug charge or what have you. And I started looking into it several years ago, and that's how I became involved in the Title IX aspect of it, as well as other college disciplinary matters, which we handle. And I've handled cases in Pennsylvania and across the country. It's important to understand when you there's two aspects of, for example, Title IX or college disciplinary cases. One is the college level administrative aspect of it, and the second is the lawsuit aspect of it, most often in federal court. So in the college administrative aspect of it, there's no right to have an attorney. You can't act as an attorney. You have to act as what's called an advisor. In Title IX cases, they're called Title IX advisors, and other college disciplinary cases just referred to as an advisor for the case. Mm-hmm. In litigation in federal court, as you well know, you need to be barred in the state or admitted pro hoc vice if it's in a state that you don't practice in. So we act as advisors for students and faculty across the country who've been involved in Title IX cases.
All right. Well, let's get to know that a little bit better. First of all, I think it's maybe surprising. It's certainly a whole world of the law that I don't really know much about, and I think functions to a large extent outside of public view because we see court cases on television, we see lawyers coming in and out of courthouses. We're familiar with that part of our legal system, but this is a whole world that is very separate. So let's understand, what is this system to begin with? We've explained to us what Title IX is, and how these cases arise. What kinds of cases are these?
Sure. Title IX was established in 1972, and it's the federal law that deals with gender equality in education. Basically, it says that you can't be denied access or involvement in an educational program from a school that receives federal funds due to sex or gender.
Okay.
A lot of people think, quite normally, when you say Title IX, it's women's sports. It's why my daughter's lacrosse team gets equal time and equal equipment and equal funds for coaching than as the boys' lacrosse team.
Right, and that has been a big part of how Title IX is played out.
Right, and that was what was in the news for so long, because sports are such a big part of our society. And I think for the most part that worked really well in a lot of cases, although there are certainly some schools that had to have eliminated certain men's sports in order to accommodate for the women's. But the arena that I deal with Title IX is really when there is an alleged sexual assault or alleged sexual harassment on a college campus. And that's where we come in to assist, for the most part, the accused students in advising them. But Title IX in general is a law that prohibits the sexual harassment, the sexual assault on campus. You can withhold, the federal government can withhold funds to a university if they don't comply with the rules.
And what are these proceedings? In other words, I think when most people think of someone alleging sexual assault or rape against another person, we think of that as being a criminal case. What are these campus proceedings, and why, and how are they set up, I guess?
Sure. So there are 6,000 colleges and universities across the country, approximately that number, that have to comply with Title IX, and each of them handles it a different way. The federal government in 2011 promulgated certain rules through what's called the Dear Colleague letter that they were telling these colleges and universities, you really need to comply with these rules.
And this was under President Obama's Education Department.
That's correct. Yeah. And so before, colleges would do all sorts of things, and some of them, quite frankly, would ignore Title IX and not treat sexual assault with the seriousness that it deserves. So what it required, what the current law requires, or what the law under the 2011 edict required, was that you have quick and rapid hearings, that there is no right to an attorney, that there is very little due process rights, and of course that doesn't apply to all schools, but I believe it applied to most schools. You don't have the right to cross-examine witnesses, you don't have the right necessarily to investigate on your own, to get information, to help you, and then you go in front of either a hearing panel made up of sometimes it's faculty and staff. It could be a non-faculty member. I had one at a college in the Lehigh Valley where there was, I think it was the IT director was on the panel, as well as students. Some schools you have the right to exclude a student if you want to. Other schools use what's called the single investigator model, which I find problematic because it's one person who's doing the investigation and then coming to a conclusion as to whether or not he thinks that there was responsibility on the part of the accused student.
So wait, so these are students who are accusing another student, or could it also be an administrator or a teacher, professor who is the accused?
Sure, it could. It actually goes beyond that. So in the scenario that everybody can probably imagine most easily is you have one student accusing another student of what they call non-consensual sexual contact or non-consensual sexual intercourse. They don't call it rape on the campus for the most part. And that can happen between men and women, between men and men. It's not strictly a straight situation. LGBTQ people are subject to the same rules, and they file complaints as well. So the complaint can come from one student against another student. They've come from students against faculty. They've come from faculty against faculty.
Okay.
They have come from students against university employees who are not faculty. The interesting thing about it is that most people are surprised that if the complaining individual, say it's two students, for example, the complaining individual or the individual that was purportedly assaulted doesn't have to file the complaint. It can come from someone else. It can come from a friend. Maybe they mentioned to a friend that they had a situation with another student and they didn't want to report it. The friend can then report it, and then the process will move forward.
I mean, that in itself is fascinating, that it doesn't even have to come from the alleged victim. It could come from a friend or family member of the alleged victim, right?
Yeah, I've never seen it come from a family member, but it could certainly, it comes from, roommates, it comes from friends, we've seen it, we've seen anonymous reports come in. There are also, under the current rules, there are what are called mandatory reporters. Which is a little bit different than in the criminal realm. Like, if a physician,
child abuse case.
Exactly, if a physician believes that a child's been abused or she's been abused, they need to report that. Mandatory reporters can be anybody in the faculty who maybe a student goes to talk to, is concerned about something. If the faculty member hears something that they think may constitute a non-consensual sexual contact or whatever, they're then obligated to report it, even if the student doesn't want to report it and comes to them in confidence. So here you have a 19, 20-year-old person talking to a faculty member, perhaps somebody that they, that they relate to well, that they go to advice, and now the faculty member has to report it.
Okay, so what we're talking about then are proceedings to investigate claims and then to somehow adjudicate or prosecute those claims within the campus community, right? These are not happening in court. These are not prosecutors like DAs or U.S. attorneys. This is all within a campus environment.
Correct.
And every campus is going to have some type of system for handling these types of claims, and how those claims get handled. According to Title IX, they have to be handled in a non-discriminatory way. Is that the basic
They're supposed
idea?
to be.
They're supposed to be.
They're supposed to be.
So then the question is, what does that mean, a non-discriminatory way? And then we get to this 2011 Dear Colleague letter that you mentioned that was issued by the Department of Education under President Obama. And as I understand it, it's a set of guidelines that were proposed for how to set up these proceedings with a threat attached to it, which is right. It didn't have the force of law per se, as I understand it, but it did carry with it a certain threat, which is if you don't implement these guidelines as we're defining them, we could remove your federal funding.
Sure, and if you're a student who feels that your school hasn't handled your case properly, be it somebody who has filed a claim of assault or discrimination, or somebody who has had a claim filed against them, they can then go file a complaint through the Office of Civil Rights, the OCR, the Department of Education. After the Dear Colleague letter came out, the number of complaints filed with the OCR rose dramatically. I think they more than doubled, easy.
And those complaints to the U.S. Department of Education's Office of Civil Rights, is that a first step in then filing a lawsuit in federal court?
No, it doesn't have to be. As a matter of fact, if you have a lawsuit pending, the OCR is not really going to look at your complaint, because that's going to be the avenue through which you handle it. So you can file a complaint with the OCR, you can file a complaint in federal court, but that's if you feel that your school has not handled your case properly, be you an accused or an accuser.
So if you file a complaint to the Office of Civil Rights, what are you looking to get out of that? A punishment of the school for mishandling it, or?
Essentially, yes.
Okay.
Yeah, I mean, what the Office of Civil Rights will generally do is they will send an inquiry letter to the college or the university saying, this is what we received, please send me your file. And then you send the file, and then it's, please supplement it with A, B, and C. And then they keep going, further and further and digging down deeper into it. At least that's the way it's supposed to work. Yeah. And then they're going to say, we think you need to do X, Y, and Z, and show us the plan that you have to accomplish X. And then the school gets together. A lot of it is corrective. Some of it, I haven't seen it be too punitive yet, but they've certainly, have the ability to do that. But right now, it's most of the things I've seen is they're trying to correct it at the school level.
Okay.
It does take the school a lot of time to try and comply if the OCR wants them to.
And you also mentioned that you can file a claim for discrimination in federal court, and that's a whole different kettle of fish. If you feel you've been discriminated in the process, either as the accused or as the alleged victim, you can then bring a discrimination claim against the university.
Well, you can, as someone who felt that they have been ignored by the university. Let's say it's someone who made an accusation of sexual assault, and they felt the university did not handle it properly. They can go file a claim under Title IX with the federal government, and breach of contract and what have you. If you are an accused, and in the past 5 years, the number of cases filed by accused students has risen dramatically. I'm going to say there's probably been well over 300 if I'm correct, but those numbers have increased, and the claims that you file in the federal court there are Title IX claims, and if there's a Title IX violation, attorney's fees go with that. You can file a breach of contract claim, because there's at least an implied contract with the university that you're going to be treated fairly when you enroll there.
And those would be cases, if filed by the accused, that some way in which the proceeding on campus was handled was unfair, was discriminatory, and they were treated unfairly in how that process was handled.
Exactly. Okay. A vast majority of those are lack of due process. And there are different requirements, obviously, between a private school and a state school. So a state school is going to have a higher requirement to comply with due process rights than a private school because they're a state actor.
Okay. All right. So we have the complaints that can be filed to the Department of Education. We have federal lawsuits that can be filed. But I think we're going to focus mainly on these adjudicative processes that happen on college campuses and universities. And to understand why, for instance, the ACLU is complaining so loudly about this, and a lot of other people are so critical of the Trump administration and Education Secretary DeVos, we have to understand what it is they're looking to reverse, or what maybe more fairly to say, they're looking to better balance. And you mentioned due process, and that's a fundamental, principle from our Constitution that both an accuser and an accused in our law should be treated fairly. And perhaps one of the most well-known ideas in the criminal law is that an accused is innocent until proved guilty. But these campus proceedings, as the Obama administration set out these guidelines in this 2011 guidance, seem to me pretty contrary to fundamental ideas of due process. And we're talking about this in terms of the Me Too movement today. Has the pendulum swung perhaps too far in the other direction? We leave a period of time when those who are claiming to be a victim of a sexual crime, a sexual assault or rape, were pretty routinely not believed. And now it seems we're in a period where we almost have to start with a presumption of believing the victim. Well, some are saying that we've now gone too far in that way, and that I think we're seeing that play out here as well. So help us understand what the 2011 guidelines they couldn't require as a matter of law, but they had a pretty strong effect, didn't they? I mean, what did that guidance essentially require?
It's funny that you mentioned the pendulum. I speak to a lot of groups on college campuses. And I was just speaking with one at a university here in Philadelphia the other day, and we were talking exactly about the pendulum scenario. Yeah. I said, the problem is the pendulum swings, and there's somebody holding the pendulum back on one side because they don't want it to get to center, because it may be easier, more advantageous to them to make their case when the pendulum is further to them. So,
and if you want, give us an example from a case too, because that may help us understand it. And I think also we need to understand, if you are an accused in one of these cases, what could happen to you in one of these campus administrative proceedings. You've got someone who's saying, I was a victim, I'm bringing a complaint, there's a process. What could happen to these accused? Maybe you have to give us an example or two to understand that.
the first problem that happens in these cases is that I don't believe that the universities adequately explain to the students what the process is all about. Now, I'm sure they'll disagree with me, but I've never spoken to a group of students. I always ask them at the beginning, who remembers their school's Title IX presentation? And, I may have 30, 40 people in a room, and I get a couple, who understands what Title IX is. So they're there, and they're college students, and maybe it's because they're speaking to them at a very technical level that kind of goes in one ear and out the other. But the first thing that most people aren't aware of is you don't get a detailed description of what the accusation is against you. So the accusation may be something along the line. That's if you get an accusation. You may just say you've been accused of a violation of the school's Title IX policy. You've been accused of non-consensual sexual contact.
How does that happen? Does someone get a letter?
They get a letter usually. They'll get a note. Actually, they won't even get letters a lot of times now. Everybody deals in email. So,
so you're all of a sudden one day you're studying your philosophy course or whatever, and you get an email saying you've been accused of non-consensual sexual conduct.
Yeah.
Okay.
Contact. Right.
Contact. All right.
Yeah. And please report to Dean so and so or Title IX coordinator so and so. Call to schedule an appointment. Or we see that your class, because they all have their class schedules. We see that your class schedule has a gap on this date between this time. Please come to my office at such and such a hall. And then they'll explain to you what the process is there. The most detailed one that I've seen is a notice that says, John Doe, you've been accused of non-consensual sexual intercourse with Jane Doe on Tuesday, March 12th at such and such dorm. That's it. It doesn't tell you what it involves.
And you're using Jane Doe, obviously, but would the person actually be told the name of the person?
Sometimes. So, we've had I've had clients who've had accusations made about sexual contact that occurred 2 years ago. I had a person that I assisted who was accused in the spring of 2018 of sexual contact that happened in December of 2012. And the school went ahead with an investigation on that.
Was that person even still in the school, or?
Well, on that case, the person didn't even go to that school, but because they were at an educational conference out of state, they felt it applied. They made the accusation, and the investigation continued. But so the notice will generally be very vague, and that's one of, I think, the suggested changes, and they still haven't been determined yet. The notice of public comment has closed on that, so we expect them hopefully to come out shortly. But more detailed information about how, or what it is the person is accused of. I'll give you an example. I had a case out in the western United States where a young man was accused of non-consensual sexual intercourse. And so he was confused because he said he verbally obtained consent, and that's one of the big things. Big thing is consent.
Yeah.
I think everybody has pretty much heard about the need for consent. If they haven't, they've been living under a rock. But verbal consent is best, but consent can also be by action. But verbal is always best. So he said he obtained verbal consent, and everything he said, kind of seemed to fall in line. And later on, about, I'm going to say 2/3 of the way through the initial investigative interview, we find out that she admitted that there was consent, but then she decided to stop. She wanted the sexual activity to stop, and in her opinion, it didn't stop fast enough. So that was the problem. She admitted that he did stop, but it didn't stop fast enough. So these are the kind of things that the student is not aware of when they get the initial notice. So when they go in for the investigative hearing, it would be great if they could come in with information that could clarify what happened, that could address specifically what happened, so that they could accumulate evidence to show what happened.
And I know you said that every campus is going to be a little different in how
Correct.
they handle these matters, but it sounds like it's generally the case that the student, let's take an example of a student who's accused by another student. They have to go in for this interview in order to find out what the accusation actually is.
Sometimes they'll find out at the interview. Well, the procedural meeting where the staff, with the Title IX coordinator or someone from the Title IX department, or perhaps a dean, tells them what they've been accused of. Other times they will receive written notice that, John Doe, you've been accused of non-consensual sexual contact with Jane Doe on or about this date at this location. That's it.
And are they told at that initial meeting or at some point early on in this process what could be the consequence to them if they're found, I don't know if even guilty is the right word here, if it's found that the allegations...
Responsible. The word is if they're found responsible.
Okay. Yeah. If they're found responsible, are they told what the consequences could include?
They should be. A lot of times they are, sometimes they're not. Every school is required to have a written Title IX policy, which clearly describes the what is prohibited. Which, let me back up. It's supposed to clearly describe what is prohibited. Sometimes it's a little foggy and a little vague, and then it talks about if you believe that someone has violated Title IX against you, and here's how you report. Here's what the school will do for you in terms of if you report a Title IX violation, or if you report assault or harassment, and then if you are an accused, here's what the procedure will follow. And then a lot of the schools will give resources mostly for the accused. Quite frankly, there are very few, if any, resources that the schools provide. Most of the resources are for the person who makes the accusation.
The accuser.
The accuser, correct.
Yeah. What type of resources?
They have women's centers. They have sexual assault survivor centers, support groups, counseling groups, and different colleges call it different things. Depending upon where you go to school, they may have a specific group just to them, or maybe a national group. The accused, quite frankly, are referred to the school counseling center, which really oftentimes does not provide a whole lot of experience. There's a great organization called FACE, and they're one of the few organizations out there, not affiliated with any particular university, that will provide support for an accused, just someone to talk to, someone who's been through that process. It's family who's advocated for campus equality. And there are some schools, I'll give credit, for example, to Muhlenberg up in the Lehigh Valley, who lists them on their Title IX materials as a resource.
Lists this group FACE.
Yeah, correct.
Okay. This is a small college about an hour
north of Philadelphia.
Okay.
Right.
Well, go back to what we were getting at earlier. So a person is accused of something that would be pretty serious here, a pretty serious accusation, and they have to go through some type of investigative process and then a hearing process, maybe. I want to understand that too, but I want, just so we understand how serious these can be, the university or college doesn't have the ability to put a student in jail, to sentence a person to jail like would happen in a criminal case in court. But what can they do? What are some of the things that can happen here?
Great question. So the college has a wide array of disciplinary processes. Anything from we're going to put you on social probation through expulsion. So you can be put on probation. You can be given an educational requirement. You can be suspended from school. So they may say, okay, you're suspended for a year, for 2 years. Oftentimes suspension will mirror the amount of time that the accuser has left in school. So if, for example, if the accuser is starting second semester of their sophomore year, you may be suspended if you're found responsible for 2.5 years from that school, and then you have to reapply to that school. So now you've lost 2.5 years. Or you could be expelled from school. They can't put you in jail. They don't have the ability to do that. There are times, however, when a report will also be made to law enforcement, and the issue that the student has there under the current system is that the schools will not delay their investigation or their hearing, if there is one, pending the outcome of the criminal case. The accused student is then faced with the difficult decision of, do I defend myself at the school level, with the potentiality that any information that I give at the school level could go to be turned over to the prosecution in a criminal case.
That's really unusual because I've been in situations where I've had a case where there was a civil case and a criminal case, and I think almost always the civil case is put on some type of hold until the criminal case is resolved.
Right.
Really for just those reasons, that the person facing criminal liability has certain rights and protections, and you don't want to have, for instance, a person who's facing criminal prosecution have to give a deposition, let's say, in a civil case while they're facing the criminal case. So one takes the lead over the other. But you're saying that doesn't happen in these campus cases.
That does not happen in the campus cases. Sometimes, most of the cases also will involve initially what we call a stay-away order. It's for broad terms, it's a restraining order. You can't talk to the person that accused you, and they can't talk to you either. There's no communication. There are schools, however, that once an accusation is made, you're suspended from school. You're out of school, off campus, can't come back until the case is resolved. Schools right here in Philadelphia that I've dealt with are like that. So there's a punishment before there's even a decision. And, well, you can come back if you're found not responsible. Well, that's great. What happens when you lose a semester? You use a semester and a half. What happens when you have student loans? The lender isn't going to understand that.
Right. Usually student loans are held. You're not obligated to start paying them back as long as you're in school.
Right.
But if you've been suspended,
right,
that could change. That could
Correct.
be a big impact. Yeah. Well, let's talk about some of the ways in which the current education department under Betsy DeVos has been talking about changing these campus proceedings, and that may help us understand something about the current system and what they're actually talking about, trying to move it to. As I understand it, one of the aspects of the proposed changes would require universities and colleges to employ a presumption of innocence to the accused when these allegations are made. Is that right?
That's right.
What?
Yeah.
I as a lawyer and as somebody who cares about the Constitution and things like that,
right.
I find that frankly pretty shocking that doesn't exist already, and that the idea of introducing that and requiring that would be seen in any way as controversial. What's going on?
Why? I don't know why it's controversial. I mean, it would seem to be natural, but it doesn't happen now.
Why?
Because
seems crazy.
I think because my opinion is because the schools were so afraid of being sued by someone who felt their case wasn't being handled properly that, as you said earlier, the pendulum swung so far. It's the suspending a student from school before an accusation has been proven, and they only have to be proven by a preponderance of the evidence.
Tell us what that's lawyer. What does that mean?
So what does that mean? That means it's commonly described as 50% in a feather.
Yeah.
So basically, it's 50.001%, whatever that may be. If it is
the
more
scale
likely,
tips ever so slightly. Yes,
right,
as every judge has explained it in the history of trials.
Right. How many jury instructions have you listened to with
right.
that? Right.
If the judge will always explain to the jury what preponderance of the evidence means by saying, imagine a scale with two pans. You put all the evidence in favor of one side on one side and all the evidence against. If it tips ever so slightly in one direction, in favor of the person making the claims,
right.
that meets that standard.
Right.
Which is a far cry from beyond all reasonable doubt.
Correct.
That's the standard in a criminal case.
It is.
So so the standard in these campus proceedings is where you have an accuser making allegations, an accused defending and denying those allegations. Fair preponderance of the evidence would mean if the scale tips ever so slightly in favor of the accuser, then the accused is found responsible.
Correct.
Is that right?
Correct. That's absolutely correct. And the problem that you have under the current system, which I think they're looking to change with the new proposals, is that well, first of all, neither side has the ability to have to cross-examine the other in most cases, right? So it's one of the
another proposed change, right?
Correct.
To allow some form of cross-examination.
Correct.
Yeah.
The presumption of innocence, the schools will tell you, well, we're going to treat everybody fairly. I mean, I don't think they would ever come out and say that they're not. Yeah. But in my experience, it doesn't happen that way. Someone gets accused, and what happens is they can be removed from dormitories. They can be removed from certain classes if the person who accuses them is in that class. So they get shuffled around. They are not allowed to, oftentimes in some schools, talk to other witnesses. They can provide a list of witnesses to the school. And then the investigation supposedly takes place. You can have an investigator who works for the university or the college, or you can have an outside investigator. There are attorneys who actually do this work for colleges, and the colleges will send it out to them. And then if there is a hearing, you'll have, as I said, a group of faculty and/or students or staff from the college making the decision. The problem is, quite frankly, if we step off the presumption of innocence talk for 1 minute, my experience is that the staff who makes these decisions on these panels are woefully untrained. To expect an economics professor and an IT director and maybe a physics professor to really have this under their belt and have a great understanding of it is, I think, it's unfair to them. It's unfair to the student. I mean, they're trained in teaching physics. That's what they do. Mm-hmm. And they're not. It's not a regular panel that sits where they hear every single case. It's not as if there's a judge in the court, and that's what he or she does. She hears the same type of cases all the time. They'll put together a panel at random when these cases, and maybe the school only has 3 a year, depending upon the size of the school. Maybe they'll have 16 a year. So they're not going to be that experienced.
Well, let me push back a little bit in a different way. Then, we're not talking about claims brought in the criminal courts. We're not even talking about civil cases, like a federal discrimination case or like some other kind of civil case where one person is claiming another injured them in some way. And that could happen here too. I mean, somebody who accuses somebody of sexual assault, that could be also brought for money damages in a civil case outside of the campus environment.
Sure.
We're talking about in these quasi-legal proceedings on a campus. I mean, I guess you could make the argument that we don't want to turn campus proceedings into full-scale legal proceedings of the scale and scope and complexity as you'd see in civil court or in criminal court, or shouldn't we? I mean, I guess that's the question. If somebody's rights are going to be affected, but whether it's the accuser whose rights to not be sexually assaulted or mistreated in some way, that person has the right to feel safe and secure and on campus. Mm-hmm. And on the other hand, you've got the accused who has a right not to be falsely accused and certainly to defend him or herself against these types of acts. So where does this fall?
Well, it's a great question. I've spoken to some general counsel for colleges who, I'm not going to name for obvious reasons, but the government is making them the sex police, is the way they feel, and they're very uncomfortable with that because I believe that they don't feel that their staff can be adequately trained that way. And look, there's been a counter argument to that with regard to the burden of proof as well. It's not a criminal case. You're not going to go to jail. It's not a civil case. You're not going to lose, a lot of money. But it should be, judged on the same civil standard. But when you go to court in a civil case, you get to take depositions. Yeah. You get to send interrogatories. You get to have your investigator go out and talk to witnesses. And many schools they certainly don't permit depositions or interrogatories. There's no discovery process whatsoever. So you're walking in there hoping you know what they're going to say.
There's no obligation that whatever information the accuser has, the alleged victim, must be shared with the accused.
So in some cases, the accused does not get to see the case file or the report file before they walk into the hearing. I've been involved in cases where I actually get the entire file to bring back to my office and work with them, which is great. I've had ones where I have to sit in general counsel's office for the university or dean's office for the university in the room with my client, with a member of the staff there from the Title IX department, and go over the investigative report, who said what and what they found and what the evidence was, and in this day and age there's always text messages and Instagram pictures and that sort of thing that you have to go over, and you want to ask the person something, but you have somebody from the school who's sitting across the room because they won't put you in a room alone. They don't trust you because you can't take pictures of it. You can't copy. I had one case.
I'm shaking my head. I know you can't hear, but I'm shaking my head listening to this. Okay.
I had a case where I jammed my finger at a very poor attempt at playing basketball a year or two ago, and so I bought an iPad with a keyboard on it to take notes of what I read. I wasn't photographing it. I wasn't copying it. But they wouldn't let me use a keyboard to take notes because they said, well, the accuser when they came in didn't bring a laptop or a keyboard to take notes. So I had to bring my partner with me so that I could point to something with my good finger and he could take the notes for me because I couldn't write with my right hand at the time. So it gets to that minutia. And sometimes, they even, this will amaze you. I believe it happened at Tulane University. There was a witness who essentially exonerated the accused or gave them an alibi. One of the, I can't recall. But they chose to disbelieve the person because he spoke with the accused's attorney. Simply because he spoke with an attorney, as if an attorney is going to tell somebody, what to say. Yeah. And of course, in any case, criminal or civil, you have the attorney has the right. If you represented somebody accused of a sexual assault, you would have the right to talk to witnesses. There would be nothing untoward about that. In fact, you would be doing a terrible disservice to your client if you didn't do those things. That would be very basic to be able to talk to witnesses, to take testimony from witnesses before a hearing or before a trial or some court proceeding. So what I guess do you see? How do you size up these changes compared to the system that's in place now? And again, there's no question you're coming at this from the perspective of representing, for the most part, the accused, although you have represented some victims as well in your practice, haven't you? Yeah, in my practice, in the civil realm of my practice, I've represented people who have been victims of sexual abuse, and I have counseled some students who were accusers as well. But the vast majority of my practice really is representing the accused.
So so size up these proposed changes then, and feel free to put it into this broader context of the times we're living in and why. It just seems to me, I'll say it. It just seems to me these measures are looking to bring some balance to these proceedings that could result in a student, some very stiff sanction, one that could have life-altering impact on a student. Just seems like we don't want to disrespect the victims here, of course, and there needs to be a way for them to bring claims to get the wrongs again, that are committed dealt with in a fair way. But at the same time, we can't be unfair to the other side here.
Sure, and that's exactly it. And I think the proponents of, in opposition to the change will say, well, it's going to make individuals more hesitant to report sexual violence on campus, or it's going to roll. I think the common term is roll back the protections. I don't think that it would make people more hesitant to roll back any protections. I think what it does is it levels the playing field. And we as attorneys a lot of time get grief because we try and we're advocates, let's face it. But as advocates, we want a level playing field.
Yeah.
And certainly I can understand why somebody would want to hold the pendulum on their side of it. But I think as practitioners of the law, we have a higher duty to assure that everything is even, that you get a fair shot. The American College of Trial Lawyers issued a white paper about 2 years ago on this. And one of the things they said in there, I really latched on to. It said that the reason that people can't accept these findings are because the process is essentially not a fair process. I mean, what I think they said was, in order to be able to accept findings of an adjudicative panel, the process has to be a fair and predictable process, and that is why, in my opinion, there's so many people who can't accept it, because it's not a fair and predictable process right now.
Well, and you also mentioned that the number of cases that are being filed in federal court where the person filing claims they've been discriminated against under Title IX, gender or sex discrimination, where the number of those cases has skyrocketed, brought by people who've gone through these proceedings as the accused, and some action has been taken against them. I take it they've been found responsible.
They've been found responsible.
And then they go on to file a discrimination case in federal court.
Right.
So,
that happens. Look,
but my point in that is that if you're highlighting one problem with a proceeding on campus that really isn't isn't being conducted on a level playing field, being the people lose faith and credibility in that process, but also you're then setting up a situation where someone has been can show that they were discriminated against, and then they bring a federal lawsuit seeking money damages against the institution. I mean, that's not a good thing.
That's not a good thing. It's not a good thing for the institution. It's not a good thing for the individual bringing the suit. Those suits are not, I mean, they're not inexpensive.
Yeah.
You know, most times these folks, you know, really what they want is they want their reputation back.
Yeah.
You know, you talked about the consequences, and look, there have been cases out, and being charged or being accused of committing a sexual assault is a really serious crime. And if they did it, then they deserve it. But there's a lot of people who have been accused who did not do it, and it alters their life. There have been kids who've unfortunately committed suicide because of it, because they never get over it. One of the most tragic cases that I consulted on was a young man who was on the spectrum. And he went through the process, and his story was that he walked a drunk girl back to her room from a lounge because he was trying to be a nice guy, and somebody teased the girl because, oh, you know, you're with this, you know, special needs student, and she was, you know,
embarrassed.
She was embarrassed, I guess, and according to him, you know, accused her of, you know, doing something, and he got expelled, and you know, and this is a young man who you know, didn't perceive things the way that you and I may, and it had a pretty serious impact on his life. And I will tell you that a lot of these cases, and he thank God was not successful in his suicide attempt, but there have been others that have. And a lot of people who get caught up in this are folks who are somewhere on the spectrum, because we have more and more kids. And kudos to the universities, because they're creating these programs for kids that are on the spectrum. University of Delaware just started the Spectrum Scholars Program with J.P. Morgan. I give them great credit for that. But there are going to be more and more kids like that in college, and how do they deal with it? They don't necessarily understand. You know, sometimes they can be very literal, and they may not understand certain boundary issues.
Well, and even before you get to, you know, kids that have issues with social cues because they're on the spectrum, and I mean, again, I have a stepson who's autistic, so I understand that very well. But But even before you get that, we're talking about, I'm thinking about the comment you made, or the comment you shared from the university administrators, is we're having to be the sex police. I mean, we're living in a time where, of course, and I have 3 daughters. I mean, the issue of consent is extremely important, but it's also, it can be very confusing.
It can.
Right?
It's
I mean,
very.
That's not to favor one side or the other. That's just being real. It can be very confusing.
Right. And I'm the father of a daughter too, and I knew that when my daughter went to college, I had to talk with her. And I said, look, this is what consent means. You know, one of the rules that I guess a lot of people are surprised to find out is that, you know, consent has to be affirmative. Okay, and that's not necessarily a bad thing, but they're just surprised because
meaning
it's not
affirmative. Meaning it has to be a yes, not a maybe.
Or no silence. You know, you talk about
or no, but I think no I think you really meant yes.
Well, that's a whole different ball of wax. That's what they call coercion. You know, no means no. I mean, right. No means no. It's a simple two-letter word. But you know, silence does not mean consent either. So there is a lot of confusion, especially at that age. You know, where it may be their first sexual contact. And for somebody, you know, especially for somebody who maybe is, you know, on the spectrum, that could be even more confusing. You know, and certainly, you know, the NAACP out in St. Louis just came out in support of the changes because a large percentage of men in particular who are adversely affected by the current policies, you know, are men of color. You know, and we do in our office. We always try and take a case or two pro bono, one a semester, because there's no public defender out there for that kind of thing. And a lot of the practitioners across the country, it's a small bar, will do that as well.
Well, otherwise you're really providing a service only to those who can afford a lawyer, and
right.
You know.
Exactly.
Are expensive. I'm not saying
no,
you're not worth it, Adam. But I mean, but for most people, lawyers are expensive.
Sure, and these cases are incredibly time and labor intensive. I mean, it's because there is no standard case, and since you can't act as an attorney in these cases, what you have to do is you have to teach, you know, a 19, 20-year-old kid how to ask a question, how to answer a question, what kind of things are important to ask, you know, how to behave. They don't understand that. You know, they don't understand when they walk in and say we were both drinking, you know, and under the rules, you know, intoxication can, you know, void consent. And they don't understand, you know, well, you know, having one beer doesn't necessarily make you intoxicated, or 2 beers doesn't necessarily make you intoxicated. So they don't know the things to look for. They don't know the proofs that they need. So imagine as an attorney having to teach your client how to go into court and present their case. That's harder than doing it yourself.
Yeah. Wow. Where do you see this going, Adam? I mean, that's part about the NAACP coming out in support of this is fascinating. I mean, are there other groups that you're seeing that this is making maybe for not strange bedfellows, but unexpected alliances on this issue? I'm really surprised at the ACLU. I would have thought they would have been, you know, I know they don't like Trump and they've raised a lot of money, you know, since he was elected on other issues, and there's no secret about that either. But on this, we really are talking about due process here.
Right. Well, I'll tell you, the ACLU, I believe, did actually roll back on their statement. I don't specifically know what it was and to what extent, but I'm almost positive they did roll back on that and say that they are in favor of due process and they're in favor for equal rights for everybody. And what do they say? Politics make strange bedfellows, but that's probably an inappropriate term for a Title IX conference. But
started it.
Yeah.
It's my bad.
But I will tell you, some of the best attorneys who do Title IX that I know in Philadelphia and across the country are women. I have some colleagues that I respect immensely. Some of the ones that I respect the most are women. I mean, from California to Philadelphia to Tennessee. I mean, and these women believe, deeply in due process and deeply in fairness. And a lot of the women, a lot of the women who are my colleagues, they go across the entire political spectrum, from conservative to very, very liberal. And in the beginning, I was speaking to a female attorney here in Pennsylvania, and she said to me, "This isn't a liberal or conservative issue."
Well, that's what I was just going to say. It's
been
politicized like almost everything these days. But when you break it down the way we're talking about it here, in the most basic terms, this is not political. This really is constitutional. This is about the most fundamental principles of fairness we have when it comes to any aspect of our legal system.
It is. And I believe that my position is that due process and respecting someone who reports are not mutually exclusive. Yeah. I'd say start by listening. Lend a compassionate ear, and to both sides. And then you'll have your chance, at advocacy. But it should not be, it has been couched as a Trump issue, but there are a lot of people who are, representing accused or advising accused individuals who are not fans of the president, but they're a fan of due process. They're a fan of fairness.
Well, it goes the other way too, right? We do live in a more, and this is maybe for another conversation another day. But on this program, we've talked about this a good bit. We are in a very tribal time in terms of our politics, and if my guy said it, then I'm for it, and if the guy I'm not with said it, then I'm against. I mean, President Obama, with this 2011 Dear Colleague guidance letter, I think there's probably a lot of people that think, well, if Obama said it, it must be good. If Trump said it, it must be bad.
I'm sure.
Right?
And vice versa.
Or vice versa.
Sure.
But if you really break it down, I mean, who can argue with the idea that if you were accused of something, especially something as serious as this, as you say, it's not disrespectful to the victim, to the alleged victim, to the accuser, to say that the accused also has rights. That's not disrespectful, is it?
It's not disrespectful. That's why I say it's not mutually exclusive. It's not disrespectful at all. It's. I think if you create a system that people can believe in the results, then you're going to have a fair system, and then people, there hopefully won't be as much vitriol. I mean, I think part of the problem is, look, sexual assault is a horrible, horrible thing. I don't think there's anybody in the right mind that would argue against that. And because it comes with so much emotion, I think that there is a tendency for people to be able to try and politicize anything with a lot of emotion.
Well, this isn't going to be resolved anytime soon, and this will be my opportunity also to give you a plug here, right? Because these regulations that have been now proposed out of the Education Department to change that 2011 Obama administration guidance is going through a rulemaking phase. What the Trump people are doing differently from what Obama did is they're actually trying to make these changes that we've been talking about actually part of the law and not merely a guidance, right? So to do that, which in itself is ironic because the Trump administration is sort of against agency law, but that's a whole other discussion too. But they're trying to get these new rules to become actually part of the law, which is a longer process, and if they do, then there'll be lawsuits challenging it. So this is going to be tied up for a long while before, from the federal level on down, it gets resolved in any uniform way. But
right.
Meanwhile, 6,000 to 7,000 college and university campuses have to deal with this on the ground.
They do.
And there's a lot of confusion about it.
There was a lot of confusion. There is a lot of confusion. They're going to have to deal with it. It's to be seen how they're going to put the infrastructure in place. That's going to be one of the key things. And I think that's one of the objections that a lot of the colleges have is, why are you putting this upon us?
Yeah. Well, if people want to get a hold of you, Adam, what's the best way for someone to do that?
Sure. They can contact me at my office at Mudrick and Zucker, 610-832-0100 is our phone number. Or they
have a website?
We have a website. Yep, it's www.mudrickzucker. That's M-U-D-R-I-C-K Zucker, Z-U-C-K-E-R.com.
Okay. Adam, thank you so much for being on the program.
Thanks for having me. It was great.